I'm thrilled to welcome you all to the Second Chances Symposium, which is hosted by the Federal Criminal Justice Clinic at the University of Chicago Law School and by the Illinois Prison Project. This country must reduce our over-reliance on caging, which is inextricably linked to slavery and to racism. Our symposium for the next 2 days aims to advance that imperative by exploring avenues for mercy for people locked up in the criminal legal system. So before the COVID pandemic hit, our federal criminal justice clinic was focused on decarceration at both ends of the system, right? We were leading federal bail reform efforts in this country, trying to reduce pretrial jailing. And at the same time, we were fighting post-conviction to get people out of prison. And we had this particular focus on people who were serving horrifically long sentences for stash house sting operations, which we believed were racially discriminatory. So when COVID descended and when jail and prison suddenly became just like exponentially more deadly and more inhumane, our students and us spent spring break really pivoting our bail reform work and our post-incarceration efforts to focus on the COVID crisis specifically. In the bail space, we worked with Congress. We worked on legislation. We collaborated with federal public defenders on motions for pretrial release. And then in the post-conviction space, we worked with the Chicago Federal Defender Program. The task there was, let's identify people in prison, people who are at a high risk from COVID. And then at that point, our students began litigating compassionate release motions, right? And these are motions that you'll hear a lot about over the course of the next 2 days. These motions were only possible because Congress had recently changed the law to grant judges discretion over a process that had long been controlled by the Bureau of Prisons. This was heartbreaking and urgent work. We were utterly terrified that if we didn't succeed in getting our clients released, they would die in prison. So for our first case, the clinic's associate director, Professor Erica Zunkel, and I worked round the clock with like an amazing team of students. And we filed ultimately 60 pages of compassionate release motions in a single week, just for one client. We had a really hard series, hard fought court hearings and filings. We were trying to detail the Kafkaesque prison regulations. And finally, at the end of the process, our client was released. And when he got home safe, he wrote this beautiful letter praising our clinic's assistance, persistence, and relentless advocacy. As I returned to focusing on our bail reform work, and Professor Judith Miller in our clinic began investigating COVID-related constitutional violations, Erica really started spearheading the clinic's compassionate release efforts. Ultimately, she secured the release of 6 additional clinic clients through that work, and she became a national expert on this issue. Our clinic's motions were adapted by federal defenders and advocates all across the country. After winning compassionate release for numerous clients, Erica and Jenny Soble, who is the founder and executive director of the Illinois Prison Project, came up with the brilliant idea of creating this symposium. So as you'll hear over the next few days, Jenny's organization is really leading the charge to decarcerate Illinois state prisons through clemency and compassionate release. Erica and Jenny have worked tirelessly over many, many months to put together an extraordinary slate of speakers and panels for you over the next 2 days. This symposium really exemplifies our mission, our Federal Criminal Justice Clinic's mission, which is to reform and transform the federal criminal legal system. We aim to be an innovative instrument of change and to push for a more merciful and less punitive world, a world that values freedom over fear. I'm going to leave you today with this challenge of memoirist Glennon Doyle. She says, what if we let ourselves feel it all? What if we decided that it is strength, not weakness, to let other people's pain pierce us? What if we stopped our lives and the world for things that are worth stopping for? These are the kinds of questions that confronted our students and all clinic students in the early days of the pandemic, and they are very good questions to ask ourselves over the next few days. I'm now going to turn things over to Erica and to Jenny, the creators of this symposium.
Thank you, Alison, and thank you so much for your support of this symposium. It is so appreciated. We are thrilled to have so many of you joining us over the next 2 days to talk about Second chances and second looks and what they're all about at heart. They're about hope, they're about humanity, they're about grace, and they're about redemption. And this conversation is so urgent given where things are in our country and our criminal legal system. We have the highest incarceration rate in the entire world, with 22% of the world's prison population. Our country's addiction to punishment and to jailing has fallen disproportionately on people of color. And I know that many of us have heard over and over again the statistics, but I want to repeat them because they're so troubling. 1 in 3 Black men will be locked up at some point in their lifetimes. We imprison Black men and women at a rate 6 times that of South Africa during apartheid. And in the federal system today, almost 60% of the over 6,000 people serving life sentences are Black. Not only does this mass jailing hurt families and hurt communities, it makes each and every one of us less safe. The Brennan Center recently found that about 500,000 people could be released today from our prisons and jails with very little risk to public safety. Yet what we know is that second chances are vanishingly rare in our state and federal criminal legal systems. On the federal side, where the FCJC does its work, there's virtually no way to get a second chance today. Parole was abolished in the 1980s. Compassionate release hasn't really lived up to its purpose, although there have been some glimmers of hope, as people can now go directly to judges and, as Alison said, bypass the BOP, the Bureau of Prisons, in asking for a second chance. We know that the clemency process on the federal side, and as we'll hear on the state side, is really broken and dysfunctional. Joe Biden has over 18,000 clemency petitions sitting on his desk. And those 18,000 petitions, those encapsulate the lives of so many people. It encapsulates their hope, it encapsulates their family's hope. Senator Cory Booker has introduced a Second Look Act, which would permit a person in the federal system to ask for a judge to re-examine their sentence after they've served at least 10 years in prison. But that act just hasn't gotten the traction that it should in Congress. And so what we're trying to do, and what everyone here in this symposium is trying to do, is to change that. Because our current approach just isn't humane. We have to do more to make second chances a reality, and we have to do more to make a lot of different types of second chances a reality. People should have lots of shots, whether it's through clemency, whether it's through compassionate release. People should have a lot of chances. So over the next 2 days, you're going to hear from the leaders in this fight for second chances. You're going to hear from people from FAM, which is used to be known as Families Against Mandatory Minimums. They are an organization that have been pushing this conversation for second chances forward for decades. You're going to hear from the Sisters in Prison Reform, who are fighting for a robust second look law in Virginia. You're going to hear from academics and lawyers who are advocating for us to take a different approach. You're going to hear from justice impacted people who are living out the promise of second chances. And you're going to hear from attorneys and advocates from Jenny's Illinois Prison Project, who have, in just 2 years, freed 70 people in our state from excessive counterproductive sentences. Their work is truly remarkable and shows the promise of second chances. Before turning it over to Jenny, I want to thank the just incredible group of people at the law school who have made this event possible. This type of event is no small feat. It takes a lot of work, a lot of people working over many months. And I'm deeply grateful to Casey Lemginko, the director of events here, her team, Alex Short and Katie Graves, who have worked tirelessly on this for months. We had originally planned for this to be an in-person event, and then we had to pivot to a virtual event because of the Omicron variant. And Casey, Alex, and Katie just did that seamlessly. They've handled all of the Zoom webinar functionality, the links, the MCLE. To say they are on top of it is really an understatement. Quinn Barron, the manager of the law school's digital communications, has done everything with our registration, our agenda, and making sure to get the word out about this event. So we really appreciate all of your efforts. A huge thanks to the Federal Criminal Justice Clinic's very own Kyla Norcross, who, as always, has just gone above and beyond to make this event a success. We could not do what we do without you, Kyla, and that's not just for the symposium, it's with every single thing we do. I also want to give a huge thanks to my colleagues who I work with every day, Alison and Judith. Alison, who has created an incredible clinic that is fighting for justice every day. You are an inspiration to both Judith and I. Judith and Alison are two of the fiercest and most fearless advocates that I know. They elevate my advocacy. They're always inspiring me to do better. And I really appreciate the time and effort that they've put into this symposium, and really for devoting the efforts of our clinic to hosting this symposium. So thank you, Alison and Judith. And then a final thank you to Jenny for partnering with us. You are brilliant, you are creative, you are tenacious, and it's wonderful to work with you. So I'm going to turn it over to you. Thank you.
Thank you all for coming. It's really an immense honor and incredibly humbling to be among such a prodigious group of thinkers, fighters, and dreamers. Erica talked a little bit about some of the horrifying statistics around incarceration in this country. At every single level, our criminal legal system is abhorrent and immoral. As Erica said, the United States incarcerates more people than any other democracy in the world. Here in Illinois, our own state incarceration rate is higher than every country in the world except Turkmenistan, Rwanda, Cuba, and of course, the United States itself. And so it's an especially difficult time to be fighting for people serving excessive prison sentences. For many of us, this feels like a tipping point. We work with clients who would have been released decades ago if their incarceration had anything at all to do with public safety or rehabilitation. Prisons in every state across the country are becoming nursing homes, as people sentenced to life or virtual life sentences enter their 70s, 80s, or even 90s inside institutions without any family or medical care. Our clients are receiving less education, poorer care, and fewer resources as the costs of this nonsensical and inhumane system continue to rise and rise. For many of us, working inside the criminal legal and prison systems feels like working inside a building on fire. Even though there are flames everywhere and we keep yelling, "The building's on fire," no one seems to be listening. Instead, prosecutors continue to seek longer and longer sentences. Judges continue to condemn people to life in prison, and governors continue to ignore clemency requests. Nationwide, and especially right here in Illinois, the news cycle is dominated by fear-mongering political campaigns that are really reminiscent of a bygone era. And far too often, rather than providing data or nuance, media giants like the New York Times fan those flames with stories heavy on emotion, but really light on facts. So in this landscape, it can feel really overwhelming to try to introduce concepts of mercy, of compassion, or of kindness into a system that fundamentally seems to reject arguments based on common sense, fiscal responsibility, or even data. And yet, at the same time, I think that there's never been a more exciting time to do this kind of work. To be clear, as long as there's been a prison system, there's been somebody screaming no, someone who's really fighting for liberation. But today, some of the most creative, innovative, and determined advocates in the world are thinking about and working on how do we free people from prison. Even better, many of those people are actually here with us today, willing and eager to share what they've learned and what they're learning with us all. So in that way, we are really, really lucky. You're going to hear from panelists from across the country who are finding new and innovative ways to challenge the criminal legal system. They are picking locks and breaking down walls, metaphorically, of course, but their work is quite literally freeing people from prison every single day. Together, we're going to examine the history of mechanisms like clemency, compassionate release, and resentencing. We'll talk about the obstacles we're encountering in the work today And we'll talk about how to build for a better future, one in which we work together to achieve mercy and second chances as norms rather than as exceptions. I want to extend a really special thanks to our panelists for sharing their wisdom and expertise with all of us. I also really want to thank Erica Zunkel for her countless hours crafting this event, for her friendship, and for her fellowship in this work. And finally, a huge thanks to Arnold Ventures, who has supported the important work of so many people in this field and who has helped make this event possible. It's our hope that you will all find new tools for your own work, inspiration from one another, and a renewed energy for the fight to bring the rest of our criminal legal system into a more compassionate future. So with that, I'm going to turn things over to Alison. Thank you all for coming.
Thank you, Erica and Jenny. You guys are always so inspirational. I love listening to you. Okay, so here we are. We're going to go directly to our first panel, which focuses on medical compassionate release. And on this panel, we're just incredibly fortunate. We have 4 experts on the issue here with us today. All of them are former state or federal public defenders. So we have Professor Vita Johnson, a dear friend of mine who teaches in the Georgetown Criminal Clinics, and she's a co-director of the Prettyman Fellowship, also at Georgetown Law. We have Professor Alison Guernsey, who's the director of the University of Iowa College of Law's Federal Criminal Defense Clinic. We also have Professor Amy Kimpel, the director of the University of Alabama's Criminal Defense Clinic, and Mira de Jong, a staff attorney with the Illinois Prison Project. I'm very sorry to say that Dr. Rachel Bedard will not be able to join us today due to a family emergency. So here's how this panel will go. The panelists will each provide sort of a brief overview of their work in this area of medical compassionate release, and then we'll do a Q&A. For those of you in the audience, put your questions in the Q&A section of Zoom, okay, not in the chat, and we will do our best to answer them if we have time. And if you're seeking MCLE credit, this is important. You have to keep an eye out. There's going to be this code that goes in the chat about halfway through our session. And you have to enter that code into a form to demonstrate that you were here and to get your MCLE credit. So throughout this symposium, we're all going to be reflecting on a central question, which is, what does a second chance mean to you? So when I think about a second chance, I actually think about Portia's line in Shakespeare's Merchant of Venice, where she talks about the importance of mercy seasoning justice, right? And then she continues after she says that, she says, quote, "We do pray for mercy, and that same prayer teaches us all to render the deeds of mercy." The fact is that every single one of us here today would want to be granted mercy if we or someone we love were locked up behind bars, right? And so it is incumbent upon us, all of us, to do everything in our power to ensure that the same opportunity for mercy is available to others. That is really, to me, the essence of a second chance. And so with that, I'm going to turn it over to Professor Vita Johnson to kick off our panel with an overview of her clinic's compassionate release work. Vida?
Hi, thank you guys so much for having me. I'm just delighted to be included amongst this amazing group of terrific advocates. Probably a number of people on this panel, I went from doing one thing in my clinic to another during the COVID pandemic. So I used to teach in a misdemeanor clinic, and then towards the end of the 2019-2020 semester of law school, we started to think about doing compassionate release work. DC passed a statute in April of 2020 that is based on, but more favorable than, the federal compassionate release statute. And through our work in our clinic with both our students and our fellows, we have freed 26 people from prison. Just the most meaningful work I've done in my career. And I'm happy to say that a lot of that success is based on our partnership with the medical school. So that's a brief overview of what I've been up to.
I, before the pandemic, and I guess currently run the Federal Criminal Defense Clinic at the University of Iowa College of Law. And it's really like a mini federal defender's office where we take trial level felony and supervised release cases and litigate them in the district courts here in Iowa. But when the pandemic hit, and even before the pandemic, when the First Step Act was passed, we started handling medical compassionate release cases across several districts, including Iowa, the Northern District of Texas, Middle District of Georgia, and the Eastern District of Kentucky. We handled those cases based on pandemic justifications. So in other words, that someone, because of their medical condition, was at increased risk of serious illness or death if they caught COVID while in prison, but also non-pandemic related issues. So someone was either terminally ill or suffering from some other illness that prevented them from engaging in daily care by themselves while in custody. At the beginning of the pandemic, as I am sure many of you who have been litigating these type of motions know, we all felt some real urgency to start to try and get our clients out of custody. We were getting calls from clients and non-clients alike, really telling us that things were getting dire. And so in addition to doing this direct representation, my clinic also pivoted to start trying to monitor the data to see whether the data that the Bureau of Prisons was producing did in fact match these really horrific stories that our clients were telling us. And you know, the Bureau of Prisons data, as flawed as it may be, and I think I'm going to talk about that a little bit later, really did reflect the experiences of the people that we knew who were being held in custody. I would just want to share sort of some of the data at the beginning of the pandemic for those of you who haven't seen what this looks like. But effectively, we saw, this is back in the spring of 2020 into the summer of 2020, we saw that as an infection entered the Bureau of Prisons, the number of infections there would skyrocket. I mean, you can see here, if you look at USP Tucson, that once one person becomes infected, carceral facilities are just breeding grounds for infection. And so what our clients and non-clients were telling us is it's getting bad in here and we need to do something about it. And in fact, there were a whole bunch of other advocates who were looking into the data and reaching really similar conclusions. The UCLA COVID Behind Bars project published this wonderful study where it talks about how quickly infections spread in federal custody and looks at the fact that they've defined extreme outbreaks or severe outbreaks in federal prison as when more than 5% of the population is infected with COVID, and noted that it only takes on average 20 days for 5% of the people in prison to become infected. So as part of our compassionate release work in the medical sphere, we really used this data and we used these numbers to try and help inform the court as to what was truly going on in the Bureau of Prisons. The U.S. Attorney's Office would claim that the Bureau of Prisons had things under control. Our graph showed that it didn't. The U.S. Attorney's Office would say, well, there's only 1 infection, 2 infections, 3 infections, no big deal. And the data would show that it wasn't. And in addition to looking at this data and going through this data, we also turned to trying to develop some design and visual advocacy projects in the hope that we could transform numbers into much more tangible human beings. And so taking inspiration from the New York Times' project, we started to track all of the people who had died in the Bureau of Prisons from COVID. And again, these are the people we are able to track because there's some problems with the BOP's reporting, but we wanted to give names to these numbers that were being cited in pleadings, and then we wanted to talk about who they were just apart from their crime of conviction. It probably doesn't surprise many of you that as the pandemic persisted, our work got much harder, in part because of what I've talked about in other contexts as compassion fatigue. As we want to take off our masks and go about our business on the outside of prison walls, individuals who are incarcerated do not have the luxury to go back to normal, but yet they're really easy people to ignore. And so one of the things that the clinic has been working on now is just continuing with these data tracking projects to show that these wild increases are not a thing of the past, and rather they continue. There's this data is just from the Omicron wave that just happened. And you can see, just like the wave last spring, that once an infection gets into a facility, it skyrockets. So in addition to this direct advocacy, my clinic has really been focusing on using numbers and design and visual advocacy in an attempt to convince courts that we really do need to release people.
So first, I want to thank the other panelists for all the amazing work they've done. I'm a dabbler as opposed to someone who's focused single-mindedly on this work in the last 2 years, and I've relied upon the work that Alison and Vida have done. So thank you for that. So I'm going to talk about some of the work. So we've done a couple of federal compassionate release cases in Alabama with my clinic. We have not yet been successful. We've had some unfortunate 11th Circuit precedent. And then we've also done one medical release case in our state prison system. And so I'm going to talk about sort of our state system and focus there, because the expertise of our panelists in the federal system far outshines mine. So I will sort of share a couple slides about the work we've done. So one of the things I think is important to understand is the context, and Erica sort of laid that up nationally, but I want to kind of talk about it particularly in Alabama. So we right now, our prison system is being sued by the Department of Justice, the federal Department of Justice, and that began under the Trump administration because of how overcrowded and violent the prisons are in Alabama. So to get the Trump administration to sue your prison system, things have to be incredibly dire. And so Alison, when she started this, talked about, what does a second chance mean to you? And I feel motivated in my work here in Alabama to say, it's not really about a second chance, right? I think I'm entitled to more than 2 chances. I give my students, my children, more than 2 chances. I think my clients are entitled to more than 2 chances. And I also think that the ways our prisons operate, particularly here in Alabama, are so traumatizing and violent and overcrowded and inhumane that there is very little that I think someone can do that can warrant that sort of punishment. And so that motivates my work. So you can see sort of what the design capacity numbers are and what our actual in custody population is here. So that's the background. Again, because of our really draconian Habitual Felony Offender Act, we have an increasingly older population. 1 in 4 of our incarcerated folks is over 50. We have a life without parole population that's the same as Georgia, which is obviously a much more populous state because of that Habitual Felony Offender Act. And so there's a huge amount of impetus and need for people to be released from our prisons. So we have these 2 mechanisms, furlough and parole, which are sort of described here, but there are real challenges and a lot of exclusions for people with violent offenses or capital offenses, which of course are a lot of the life without parole or death by incarceration population. The parole situation in Alabama is bleak. That's part of the reason our overcrowding has gotten so acute. You can see that in 2021, which is the 2nd year of the pandemic, our grant rate was 15%. And then if you look at that broken down, the racial disparities are really bad. So it's 9% if you're a person up for parole in Alabama and you're Black. And the medical parole situation, we have this statute that is not super robust, but then in its application, 4 people were granted medical parole in 2019. And in 2020, the first year of the pandemic, we had 5. One of those was our clinic's case. Medical furlough, the other avenue, it's not much better. We currently have 8 people on medical furlough in Alabama, and you can see that there's no year that they've released more than 13 people into that program. So there's just so much work to be done and so many challenges, both the people with violent offenses and then the real logistical challenges, like getting medical records from some of these state prisons. Federal system has a lot of problems, but you can get those records by email without having to pay. And a lot of our state systems, they're charging you per page, which is difficult in pro bono work. Getting physicians' reports, particularly because a lot of those folks have relationships with the Department of Corrections. And then getting reentry services like medical care once they're released or housing can be real challenges. But it's worth it. So this was our client, Justin, reunited with his wife, Amber, who was his fiercest advocate. And he was able to be released with stage 4 cancer. And so he was able to spend nearly the last year of his life with his family before he passed this fall. So even with those numbers, it's worth doing this work, and it's tremendously inspiring. And the students who worked on this case, Chisholm Allen Lundy, Alan Slater, and George Peterman did tremendous work to release this one client, that one of 5 who was released under this statute in 2020. And then I'm also on a board of a nonprofit in Alabama. So if you're interested in sort of supporting our nonprofit that's doing parole representation for aged and infirm folks, check out Redemption Earned Alabama, which is a new nonprofit. That's what I got.
I'm so happy to be here with all of you. So I guess I wanted to start with the question of what does a second chance mean to me? I think for me, it's about the recognition that no person is disposable and that no person deserves to spend decades or an entire lifetime in prison. And it's also about the fact that there's no one thing that a person could do that would make them not worthy of dignity or love or safety. And when I think about that dignity, I include death with dignity in that. So I want to tell you about the work that we've been doing at the Illinois Prison Project on behalf of our medically vulnerable clients, and to tell you about the new compassionate release law that we have here, which is very exciting. So up until very recently, we were one of just 2 states that did not have a compassionate release law on the books. And if an incarcerated person was very sick, the only options that they had to try to get out of prison were clemency or medical furlough, neither of which were very good options. So in Illinois, as pretty much everywhere else, it's very difficult to get clemency, and it's not on any timeline. So the reality is that people who are very sick are going to die while they're waiting for a decision on their clemency petition. And the other option that we had, medical furlough, was also not a great option, primarily because the decision maker there is the Department of Corrections, and it actually requires sign off at 4 different levels of the Department of Corrections. Also, a life sentence means that you are ineligible for medical furlough. So some of the oldest and sickest people couldn't even qualify for it. And if you do get medical furlough, you are essentially on house arrest. So you have an ankle monitor. You can basically only leave your house to go to a doctor or a very limited number of approved sites. So clemency, medical furlough, neither great options, neither had a super clear decision-making process or any sort of built-in timeline. But as of January 1st of this year, the good news is that we now have the Joe Coleman Medical Release Act. And that is a compassionate release law that creates an expedited pathway out of prison for people who are terminally ill and very sick. So this law is named after one of Jenny Soble's former clients, Joe Coleman. He was a decorated Vietnam War vet. He had a big supportive family, a super impressive institutional record, was serving life in prison for a nonviolent robbery, and he had terminal cancer. But because we didn't have a compassionate release law, Joe Coleman died in prison while he was waiting for a decision on his clemency. So the compassionate release law is named after him. And I want to tell you now just a little bit about how it's structured and how it's been going so far. So the law says that to qualify for medical release, you have to be either terminally ill or medically incapacitated. So terminal illness in the law means likely to die within 18 months, and medically incapacitated is either requiring assistance with multiple activities of daily living, like bathing or eating, or there's this slightly fuzzier definition that says you are medically incapacitated if you are so sick that incarceration does not pose any meaningful additional restrictions. Under this new system, an application for medical release is filed with the Prisoner Review Board, basically our parole board. And unlike clemency, the governor is not involved in this decision-making process at all. Within 10 days of filing, the department is supposed to perform a medical evaluation and then send those results to the Prisoner Review Board. Victims and prosecutors are notified, and they have 30 days to submit opposition letters. You do have a right to a public hearing, although we think that the process will go faster if you waive that right. And then within 90 days of the original filing, a decision is made by a 3-member panel of the Prisoner Review Board. And if a simple majority votes in your favor, then you are going to be pretty much immediately released. Now, in terms of how this is going so far, we know that 67 cases have been filed in total, not all by the Illinois Prison Project, but by a variety of people, including incarcerated folks applying on their own behalf. 23 of those applications have been shut down because they were found to not meet the medical criteria, and that's based on the medical evaluations that the Department of Corrections did. So it's kind of problematic, and I'm going to talk about it a little more later. And 2 applications have been granted so far. Those 2 that were granted, they were both very sick, terminally ill. They both waived their public hearings. And one of those people had previously been denied medical furlough, but now he has been granted medical release and he's on hospice care in the community. So I think that is a good omen for how the implementation is going to play out, that someone who was denied before has now gotten out. And although there's definitely been some growing pains and some questions about how different stakeholders are interpreting this law, I think that we are going to see a lot more folks who are very sick getting out of prison in the coming months.
Thank you, Mira. The work that that you and Jenny and the Illinois Prison Project are doing is really incredible. So I now am going to ask the panelists some questions, and I think we'll start with you, Vida. So we've talked a bit about your clinic's incredible success with compassionate release motions, getting so many clients released in DC. And from our conversations, you've said a lot of that has to do with these partnerships that you've forged with medical experts. So what advice do you have for people, practitioners who are litigating compassionate release motions, as far as finding experts, collaborating, and working with medical experts on those motions?
Yeah, so we've really been so lucky to partner with our medical school. Georgetown Medical School has a health justice track. And so the medical students that we work with come from students on that track. So in their 4th year of medical school, students do 1-month rotations in a variety of specialties like obstetrics or oncology. But the health justice students can also choose to spend a month with us as one of their rotations. And so they help us make sense of the medical records. And so we've been able to do that for now about 1.5 years. And I think there's kind of 4 things to look for in a medical compassionate release case that I probably would not have known to look for if it wasn't for our partnership with the medical school. So the first is really not just simply identifying the medical issues in your compassionate release motion, but truly explaining what they mean. We hear terms like resistant hypertension, diabetes, or chronic kidney disease. And we hear them so often that we really make people pause about them because our country generally is fairly sick and these are relatively common ailments, but they're deadly ones, especially in prison. And so explaining how deadly these conditions are individually, on their own, but also for people who have multiple conditions. And it's just to communicate how much these conditions reduce our clients' life expectancy in layman's terms is hugely important. And I'm not sure that we fully appreciated those things until we were able to work with our medical partners. So that would be my first bit of advice. Second, I would make sure that any submissions for compassionate release point out any conditions that can't be recovered from. So for example, once someone passes beyond stage 3 of chronic kidney disease, the loss of kidney function is permanent. That's just function that will not be recovered. That person has lost the function of more than half of their kidney. Once someone has reached that point, there's just nothing that can happen for them. And then they will eventually, after stage 4, will go into end-stage renal failure, where they'll either need organ transplant or dialysis for the rest of their life, which will be short. For example, if you lose feeling in your feet from diabetes, that might not seem like a big deal, but that's feeling that is completely non-recoverable, that's irreversible. And so I think it's important for judges to realize how serious these common ailments become in prison because of how inadequate the medical care is in these settings. The third thing that we've really started to focus on are medical lapses. So if, for example, this diabetic client is only having his A1C checked once a year rather than every 3 months, explain in your motion how that deviates from the standard of care. Look at lab values and see whether the medications that are being prescribed to your clients are actually having the intended effect. We've seen multiple clients who are on 2, 3, 4, and sometimes 5 hypertension drugs, and none of them are working. They still are having high blood pressure readings, and that means the person is headed either for a heart attack or a stroke. And so really making sure that that the judges fully understand how deficient medical care is in these prison settings. And it's hard to do because we're lawyers, right? And we're talking to someone with the same legal training that we have, but we need to make them understand how serious these medical conditions are. And then finally, because judges have grown more resistant to granting compassionate release motions since vaccines have become widely available, pointing out whether your client has a health issue like HIV or is on some immunosuppressant drug that might mean that they're not going to have the same response from the vaccine as someone else might. And so I would make sure to make that a big focus of your motion as well. I know that not everyone will have a team that they can work with, but having medical expertise that they can rely on and an expert they can chat with, even if it's like your friend's cousin who's a doctor, with your client's permission, of course, is a huge part of winning these medical compassionate release motions.
Thanks so much, Vida. It's incredibly helpful. So I'm going to turn next to Alison. You've talked, so we're, here we are, we're 2 years into the pandemic, and we have all heard judges express the hope that compassionate release will just go away, disappear. This idea that maybe compassionate release is really just like a function of the pandemic, which it isn't, which it wasn't originally intended to be, but that's sort of, there's a connection that's been developed, like I think in the judges' minds, right? And you talked in your introduction about this idea of compassion fatigue. So I want to draw that out a bit and get a sense of, how does the fact that there's not great data from the Bureau of Prisons, even though you guys have mined the data amazingly, but there's not great data from the BOP, how does that maybe fuel the judges' hostility to compassionate release? And even more importantly, how can practitioners use that to sort of overcome judges' compassionate fatigue, or any advice you have for practitioners about dealing with compassion fatigue?
Yeah, so I want to start by just showing a quick slide that shows sort of rates at the federal level, because we only do this at the federal level right now, but show the rates of grant of compassionate release during the calendar year 2020 and 2020 to 2021. And so when we talk about compassion fatigue, we also have to remember that when we had a lot of compassion happening, it wasn't all that much compassion. Like, it was relatively high in terms of judges were granting these motions, but it's not as though they were opening the prison gates, tearing down the prison walls, picking the locks, as Jenny said. So in the calendar year, the United States Sentencing Commission is reporting that there were about 20,000 compassionate release motions filed. Now, they don't break down how many of these were medical compassionate release motions versus other types that you'll talk about, I think, tomorrow. But of those 20,000, only about 17% were granted, and that's about 3,600. And so for the people in some districts, some of these districts that are highlighted in green, it was probably much more likely that you were going to have success than some of these other districts, the districts highlighted in orange. And in those districts, there wasn't ever really a lot of compassion to start with. I mean, if you look at Western North Carolina, there were 2.7% of the compassionate release motions were granted. Eastern Texas, 2.2, Southern Georgia, 1.7, as compared to, I think it's Puerto Rico, who had 77.6%. 0.3% granted. So I think there's been really large geographic disparities since the beginning. And so now we're even getting into lower and lower numbers. And in the districts that weren't favorable or weren't granting a lot of compassionate release to begin with, this means essentially, for all intents and purposes, there is no medical compassionate release, at least as it's based on the pandemic. And it really is, Vida mentioned this, but it really was the first time that we started to see a decrease in these grants was when the majority of the prison had already got infected. And so people were arguing about reinfection. And district judges were simply saying, well, given the data that we have, it's really unlikely that you're going to get reinfected. And if you do get reinfected, we think that it's actually going to be less dramatic for you. And so what we started to do was look at the data that we could about rates of reinfection. And we found that of the over 300 people who had died, the Bureau of Prisons reports that at least 39 of them had been deemed recovered from COVID when they, in fact, were then reinfected and died. So using this data, we tried to show judges that, wait, reinfection is a real thing. And not only is it a real thing because it can result in medical complications, but for at least these people, it also resulted in death. The second thing that was really the driver is as soon as vaccinations started becoming more commonplace in the Bureau of Prisons, judges started to rely on the fact that someone could get vaccinated to deny compassionate release motions. And it's problematic for a number of reasons. The first being it just assumes that we're going to have a strain of COVID that's going to not be vaccine resistant. And it also really depends on high rates of vaccination in the Bureau of Prisons, and we simply haven't gotten there yet. Now, and in fact, I showed this slide earlier, but if you look at the surges during Omicron, and it's very similar to what we were seeing in the spring 2020 waves, as well as in the Delta waves. And in 2022, so we're now in mid-February 2022, this year thus far, there have been at least 12 deaths from COVID in the Bureau of Prisons. So this notion that we shouldn't have to worry about this anymore is really not borne out by the data we have. But what makes it even more frustrating is that the data we have is clearly incomplete. There are really two big problems with it. The first is that the Bureau of Prisons does a terrible job reporting it. They're supposed to report a cumulative infection rate every day so that you can see how many people are, one, infected at any one time in a prison, but two, how many people have been infected over time. But the Bureau of Prisons has decided that it actually just wants to remove people from that running cumulative tally. So we really aren't ever going to have a good idea of how many people over time have been infected in prisons. And so we track every day the number of COVID infections that the Bureau of Prisons is reporting. And you can see this on this slide. All of the red boxes on this spreadsheet are days when the data doesn't reflect the reality. So if we're keeping a cumulative total of infections in the Bureau of Prisons, the number day to day should never drop because it's always going to include infected people and recovered people. But all of the boxes in red are the days when, in fact, the data has dropped, which means that the Bureau of Prisons is simply removing people from its tally, really hiding the true, the true aggressive nature and also the real human toll of what's happening. I mean, if you look at Carswell here down on the bottom, this is from this year. So January 20th of this year through February 11th of this year, you see Carswell was reporting on January 24th, 1,027 infections. And then on January 25th, just the next day, they miraculously had a dip of over 30 infections. And so when judges are relying on this data, as advocates, what we really have to do is argue that it's flawed. You can't rely on this data because even the Bureau of Prisons admits that it's been playing with the numbers. But not only this, right? Even if you take this data as legitimate on its face, the other problem we have is the Bureau of Prisons is not reporting what its testing requirements and protocols are. So we have no idea whether they're even testing people who become sick. And of course, your data is only good as your testing. And if you're not testing, then you're never going to develop a really good sense of whether or not the low infection rate is a real infection rate or whether or not it's a function of your failure to test. Again, UCLA COVID Behind Bars project, they have some amazing data scientists who've looked at how the Bureau of Prisons, the Federal Bureau of Prisons tracks vaccination rates, and it's an outlier. If the Bureau of Prisons counts, testing, not vaccination rates, the Bureau of Prisons counts testing and they count every person they test as opposed to every test they administer. So if I were tested 10 times, I would only come across as having been tested once. And it really hides the true rate of how frequently they're testing, when they're testing, and whether or not this data can be trusted at all. So I think the big takeaway from this is that when we go into court and we're litigating these motions, we really have to take the government, we have to hold the government to the fire and say, this data that you're presenting, this argument that the Bureau of Prisons has these things under control is simply not supported because we don't have access to the information that we need to be able to make those conclusions. And so to engage in maybe some additional discovery practice to try to get this information from the Bureau of Prisons. I mean, at this point, I have several FOIAs outstanding. It's the only really way that I've been able to get the information that we need. And so I think as you have clients who are facing more and more dire circumstances as the pandemic continues to go on, discovery litigation may in fact be one of the ways that you can really push the envelope forward.
Thanks, Alison. I just have a quick follow-up, which is in your work and your litigation, like how amenable have judges been to, does conveying the depth of the problems with the data, the lack of availability of the data, the fallacies in the government's arguments, does that actually help? Has that been actually helping in the sense of getting people released, or how is it working in that way?
Yeah, I mean, definitely not in the districts where I practice, but my districts fall within those districts where compassionate release is not really granted that liberally. I do think, however, that it has pushed at least lawmakers to start to pay attention to what the Bureau of Prisons is and isn't doing. And so there are some broader nationwide initiatives coming out of the various people, and because it's obviously not just me, but the various people across the country who have been doing this work and tracking this data. And so, I mean, at the very least, I'm hopeful that there will be some reform on a larger level. So as we move forward with this kind of work, which is, it's not going anywhere. I mean, we're all sort of deluding ourselves if we think the pandemics are going to stop. At least we may have better data in the future. But I do think, the government has an obligation to argue truthfully to the court. And I do think that it's very difficult for them to stand in court or to put in a pleading that the Bureau of Prisons has things under control when we know from the data they made public that they don't. And we know from the data that they are holding back that it's likely that it's even worse than we think. And so again, I think just emphasizing that we can't just assume things are under control based on what we have, and we really need to push for better information.
Thank you. And I do hope that especially the work and the data you're showing around Omicron can help judges see that it's not as if the pandemic is sort of over as soon as people are starting to get vaccinated, because with each of these new variants, there's new threats. So thank you.
And can I add one more thing that I just
Sure.
think is important? So one of the things that I had asked for from the Bureau of Prisons is a list of all of the deaths in custody, regardless of the cause of death. And so we're in the process now of going through the various deaths in custody, but it's been quite striking to me how many people have died during the pandemic from non-pandemic related causes. Suicides, incredibly high, things like sepsis, incredibly high, kidney failure. And I can't help but think there's also some connection to the pandemic because these are preventable, some of them are preventable diseases that we should be able to otherwise control. And as the Bureau of Prisons is funneling their resources towards trying to prevent the pandemic or the virus from spreading in the carceral facilities, they really are ignoring just routine healthcare. So I think that when we think about compassionate release and a pandemic-related compassionate release, it's not just people who are at risk of getting COVID, but it's all these other people who are really, really ill and who are not going to get the care they need just in the routine course.
Thank you. Yeah. Amy, I'm going to go to you next. So yeah, how do you litigate? How do you advocate these kinds of compassionate release motions in a fairly hostile jurisdiction?
So I want to get to that. I want to sort of just piggyback on one thing Alison was talking about it's not just that there's lack of medical care, but it's also that for our folks with high medical needs, a lot of times they're going to be, not able to go to a chemotherapy appointment because there's not enough staff, because the vaccination rates of staff are really low, the infection rates of staff are really high. And so it's just hard to sort of get the people to move the people where they need to be to get the medical treatment. And then when they come back from those visits where they're getting care elsewhere, they're often in the infirmaries, like 2 doors down from the people who are being quarantined for COVID. And often those people who are going to the infirmary for that other medical care are those who are at high risk of death or serious illness if they do contract COVID. So all these things are really overlapping. Same thing, Alison's talking about the high rates of suicide. People are not getting the mental health treatment that they need. People are also being isolated in cells. And then the bigger issue is at the same time as we have these officials saying, oh, we've got it covered, they're also saying, yeah, but we aren't going to be able to let you see your family members for 2 years because this pandemic is raging. And then when we do finally get in-person attorney visits, you're going to go into these facilities and see correctional officers not even wearing masks, right? So there's all this really inconsistent language that we're hearing from the government and from these carceral facilities, right? So I just want to sort of put that over to one side to sort of echo Alison's frustrations. Because it's one thing to say like, oh, COVID isn't a big deal, so we're not going to release people. But then at the same time, we're not going to let you see your family members in person for 2 years. And the impact that has on people's mental and physical health when they're not able to access those resources, and that's familial support. Okay. So how do we litigate in places where it's difficult to get grants? So I think like a few things. One, part of this is about bearing witness and sort of raising awareness about some of these issues. And sometimes being on the right side of a fight, even if it's a losing fight, is worth it, right? Like I'll say we weren't getting hearing on one of our state habeas cases at the beginning of the pandemic. And I just wrote the list. I said, I want a status conference because these are the names of the people who have died of COVID since we filed this motion and nobody's responded. We got a status hearing, right? So sometimes you just have to sort of say that, like, we can't pretend these people don't deserve some advocacy, even if we aren't able to be successful. The other is just persistence. Like the number of hours that my clinic students have logged just calling different BOP and ADOC officials and listening to the phone ring for 20 minutes or calling and being transferred to voicemails that never pick up. And you just have to call and email and keep on sort of pounding the pavement. It's not all legal research and writing in these cases. There's a lot of logistical challenges that are by design, right? To make it difficult and to sort of disincentivize us from fighting on behalf of these really marginalized populations. And so I think it's really important in light of all that, and something that's been important to me is to build community, right? To like know the other people in your state and nationally who are doing this work, who you can vent to, that you can share strategies with, that you can brainstorm. And I can't tell you the number of times that I scheduled Zoom calls with Erica or send things on the listserv that Alison or Vida responded to, sort of say like, I don't know how to handle this, and both in-state and out of state. I've had tremendous support from people at Alabama Appleseed, SPLC, Southern Center for Human Rights. And I think it's so important to have those communities and advocacy communities to be able to sustain yourself in this work, because it is really draining to have a phone call with somebody who is in these conditions and you are not sure whether you'll be able to get them released before they die. So I think that's really important. And then I think the last thing is, at the beginning of this panel, Alison Siegler introduced us all as experts. We were not all experts 3 years ago. In fact, I still don't claim to be an expert, but I think that one of the things that's really important is to sort of say, like, you don't have to be an expert to start doing this work. You just need to be comfortable asking questions, comfortable asking for help. And I think those are really important, and to build those relationships. And we have been doing that in Alabama with my nonprofit, right? Like the executive director who I work with is, scheduling lots of phone calls, scheduling lots of meetings with different people throughout the state who are going to be able to support our work and facilitate our work being more successful. So we can hopefully change those grant rates because we build some reputation and accountability, and then people are able to give a grant when we're appearing on a case and saying this person's not going to be a danger if you release them, because we've established those relationships and there is trust built.
Thanks, Amy. I consider you all experts, certainly by now. I know you're being modest, but
Alison, can I just jump in on that really
Sure.
quickly? So I think it's really interesting because I was an assistant federal public defender for so long, and my clinic is relatively new. But one of the things that has just shocked me about litigating these compassionate release motions is how wonderful law students are at spotting things that I have become just desensitized to. And so one of the things that may be helpful for practitioners who've been doing this for a while is that we have these clinics, and it may be worth reaching out to people who are litigating these type of motions and just having a law student sort of do a gut check for you on what it is that you're arguing. Because I just assume, right, like I've just become to accept that the Bureau of Prisons is a certain way. And my law students are not willing to accept that yet. And so they push back and they push buttons and they think creatively in a way that frankly, I don't always. And so I think that that's really showing someone who hasn't become desensitized to the horrors that the Bureau of Prisons is inflicting upon people can be a really good judge as to where you can push your litigation.
Do any of the other law professors want to jump in with anything about the experience of litigating these motions with students while we're on that issue?
I mean, I'll just echo what Alison said, and I think, we get desensitized, but then also sometimes I think I'm asking for too much, right? And like, I'll have a student who's like lifetime Republican who's like horrified by what the Department of Corrections is doing. And that's a reminder also, right? They're like, this doesn't make any sense either fiscally or from a humanitarian perspective. And you're like, oh, okay. Like the stuff that I think is just my bleeding heart liberal self is actually like just reasonable people looking at something that we like to ignore.
I'd also just add that it's just an incredible experience for law students. Law school is a very disorienting experience for some people, and to actually have a human being on whose behalf you're fighting is incredibly meaningful. And the conversations and the correspondence that these students have with their clients is really life-changing. And so we've had students go meet clients who've gotten released or continue corresponding through Corlinks past graduation, because those relationships are so important to them as humans. So any law students listening in, I highly recommend that you get involved in this work because it is really incredibly rewarding. Sometimes I think the best thing we do is just let people who are caged against their will know that the world hasn't forgotten about them.
I couldn't agree more. I mean, when COVID hit and everyone was freaking out for themselves, right? I was just floored by how incredibly selfless and giving our students became, even as they were in the middle of an incredibly traumatic experience. Like they were just totally showing up for clients. I had students coming out of the woodwork who weren't even in my clinic, many students saying, can I do something with your program, or somehow can I work with some federal defenders? Can I help, with other public defenders? Can I do something for the people who are behind bars? It was like, it's just totally remarkable, the way that the law students have shown up. So I'm now going to turn it over to Mira. Next question to you, which is, I want to go back to what you were talking about, the Illinois Prison Project, which created this new law, the medical release law that went into effect in Illinois the first of the year. So from what you said, this law situates the decision maker as the prisoner review board, right? Not judges. So different from the federal system and a lot of systems. We've sort of talked, this group has talked about the fact that like a lot of states have medical release laws, but very few people are released, maybe in part because of eligibility criteria, which are too narrow, or people with decision-making authority having, very little incentive to promote and, effectuate releases. So how did you all go about creating this different and really effective medical release law? And more importantly, sort of what advice do you have for other people who want to try to create a new kind of medical release law in their own jurisdiction?
And I will add a big disclaimer up front that I am no expert on the legislative process or on statute writing, but I have talked with Jenny a lot about how this law got passed. So yeah, I think that if you are trying to write an effective compassionate release law, the biggest picture questions that you have to ask are, what's going to be palatable in your jurisdiction? What can you actually get passed? What are the eligibility criteria that are going to help the greatest number of people while also being something that you can get broad support behind? And like you said, who's going to be the decision maker? Because if you are asking the Department of Corrections to be the decision maker, that's probably not going to go very well. But in terms of what is palatable, that's definitely going to be a jurisdiction specific question. So something that we could get passed here in Illinois is probably going to be very different from something that you could pass in somewhere like Florida or Arkansas. What Jenny told me about writing this bill is that they tried to leave a lot of space in it and flexibility so that people who would not automatically be an ally could have an opportunity to buy into it and to actually meaningfully contribute to the statute and maybe come over to our side of the aisle if they weren't there before. But I think the heart of the question of how to write an effective medical release statute, not just to write one, is to decide what are the eligibility criteria, who, if anyone, will be excluded, and what are the factors that the decision maker is going to consider. So our statute is broader than some other states, but also in other ways it's pretty limited. Under our law, you have to have a prognosis of less than 18 months to live or meet this definition of medical incapacity. And that's different from something like the DC statute, which includes people who are over 60 and have served over 20 years, regardless of their health. But I think the fact that our law doesn't resemble something like elder parole is part of the reason why we were able to get it passed. And we did make room in it beyond just terminal illness. We have this medical incapacity category, but we didn't go so far as to say that just being an elder in prison qualifies you for relief. But maybe if you're working in a less hospitable jurisdiction, maybe the only way you're going to get something passed is to say that it's limited to terminal illness. I think that's an area specific question. But the flip side to the question of what are the eligibility criteria, it's the question of, is anyone going to be excluded from this statute? Are there going to be certain convictions that disqualify people? That might make it easier to get the law passed if you do that, but that's not necessarily going to be a very effective law, because the reality is that the folks who are convicted of things like murder, they're going to be serving the longest sentences, they're going to be the oldest, and they're going to have the most extreme health problems. So if a compassionate release statute excludes people who are convicted of murder or who are serving life without parole, that would undermine the policy reasons for creating a compassionate release law in the first place. So in our statute, there are no exclusions based on conviction or sentence. And I know that we are getting pushback on that already and seeing some fear mongering in the press in response to someone who was convicted of murder being released. But the reality of it is that compassionate release is not a radical leftist idea. We are actually very late to the game in Illinois in terms of enacting a compassionate release law, where we were one of 2 states that didn't have one. And the people who are getting out on this law are actually very, very old and frail. But beyond setting the basic criteria for eligibility and thinking about who is excluded, if anyone, you also have to think about what factors are going to be considered by the decision maker. So you mentioned in your question that people with decision-making power might not always have an incentive to grant compassionate release. So one factor that is included in our statute, or that's supposed to be considered, is the cost of an individual's healthcare and the impact that their continued incarceration will have on the larger prison healthcare system, how it will impact the care that other people receive. So, I hate the financial argument because I think that decarceration is about, human rights. It's a moral issue, not a practical one. But this factor does take into consideration that it's a huge waste of money to be incarcerating the elderly and the very sick. So maybe that is an opportunity to get buy-in from people who care more about the financial argument than the human one. Another thing to consider in terms of writing factors is what kind of influence will a victim or victim's family member have on the decision-making process. Can you include them in the statute in some meaningful way while also making sure that the desire for retribution isn't running the show? Realistically, I think you do also need to include something that acknowledges concerns about public safety, but you don't want to include some sort of vague dangerousness factor that is going to be used to indiscriminately deny applications. So our standard for basically the public safety factor in the Illinois statute is the likelihood of and ability to pose a substantial danger to the physical safety of a specifically identifiable person or persons. So that's a pretty specific standard, and it acknowledges concerns about risk while also making sure that this is not going to be weaponized. It's just a blanket reason to deny all applications. And then I know you mentioned the decision maker, and that's, I think, the last and one of the most important considerations is, who is going to be deciding on these motions? Is it a judge? Is it a parole board, the Department of Corrections? And again, that's going to be a jurisdiction specific question, but you have to think about who has made release determinations in the past and who is going to be able to make the kind of time-sensitive decisions that are so necessary for people who are terminal. So our decision maker is the Prisoner Review Board, and we know that they have a lot more capacity than the courts to quickly process an application. And we also know that they're going to be more receptive and more sympathetic to our clients than the Department of Corrections would be. And I can't personally think of a good reason to make the Department of Corrections the decision maker, unless maybe that's the only way that you're going to get something passed. Maybe that is working in some states, I don't know, but that just aches me out, the idea that the Department of Corrections is deciding who gets out and who doesn't. And they were making a lot of these determinations in Illinois before when they were deciding medical furlough, and they were very reluctant to grant it. And I mentioned, at the outset that we are actually seeing that the Department of Corrections is maybe still playing too large of a role in these decisions, even though the Prisoner Review Board is the ultimate decision maker. We are seeing that the Department of Corrections medical evaluations are just shutting down the process in some cases. Something like 1/3 of the cases that have been filed were shut down because the Department of Corrections said this person doesn't meet the medical eligibility. We don't think that's an accurate interpretation of the statute, and it's something that we're concerned about and trying to fix. But yeah, I think probably anyone will face obstructionism from the Department of Corrections and an attempt by them to cover themselves from liability, because I think some people are very sick as a result of the substandard care that they've received in custody. So maybe there are some cases where the department is going to say this person doesn't meet the requirements because they don't want to acknowledge what they've done. But aside from that, the question about who is going to be the decision maker is definitely closely tied to what kind of timeline you can build into the statute. So our statute has a 90-day timeline. And that's something that the Prisoner Review Board can handle, but that it would not have been possible to ask the sentencing judge to do. So maybe in some places it would make sense to have the sentencing judge be the decision maker, as it is in DC, where the courts are relatively efficient and it seems like it works. And the benefit of that is that you have a published opinion, a clear record, and a clear appeal process. But if we were to ask a sentencing judge in Cook County to decide on a Joe Coleman application, that would be sitting on a desk somewhere for way, way too long. And people would continue to die while those applications were pending. And the law would not be serving its function, which is to help the terminal and the very sick get out of prison and live out their final days of dignity. So I think, the main points that I touched on, think about what's palatable in your jurisdiction. Think about eligibility criteria that are narrow enough to be palatable, but not so narrow that it's nearly impossible to get relief. Think about who is the right decision maker and who can make time-sensitive decisions. And of course, make sure that you are centering the people who have the most urgent need for compassionate release which is typically going to be people with the most serious convictions serving the longest sentences.
Thanks, Mira. That, it's so interesting listening to you talk about some of the elements of the law that have been the most effective, because in some sense they seem sort of a little bit like logistical or whatever, like that idea. I mean, the timing just seems absolutely essential. And I know that those of us practicing in the federal system have seen that, I mean, it's a wildly disparate how quickly judges will rule on these motions, even when you're saying, my client might die in prison. And there's just nothing like that kind of timing requirement that exists. And so it's really, it's great to hear you talk about that. And it's great, I think, for anybody thinking forward looking, trying to make these laws elsewhere. But then the other thing is this idea that the cost is something that can be considered, because I know, and I know lots of us who practice in the federal system have also tried to make cost arguments, whether at sentencing, whether at bond, talking about the incredibly high cost of locking somebody in jail or in prison. And what we're frequently told is that's nowhere in the sentencing statute. That's nowhere in the bond statute. I don't see anywhere that allows me to take cost into consideration. And so the fact that cost is explicitly there, even though I understand why it can feel very offensive to you and to many of us. And yet at the same time, I think it can be very helpful because some people are really moved by those efficiency, and economic arguments. Now that we're talking about laws, I want to ask Vida, I know it sounds like, DC often feels to those of us in the federal system like federal better, federal plus. So like, what does the DC law do better than the federal law in this regard, in this area?
Let me say that DC is no fairy tale land. 95% of the people who are in prison on DC felonies are African American, despite Black people making up less than 50% of our population. And, we certainly have a very high rate of incarceration compared to the rest of the country. That being said, I do think there are some players, particularly the DC Council, that are interested in making those things hopefully issues of the past. So our statute is modeled after the federal compassionate release statute for a step back, but it is different in two ways that are incredibly important and that have helped us tremendously in securing release. One is it makes people automatically eligible after being only 60 years old, rather than I think in the federal statute it's 70. If they've served 20 years or more in prison. But probably the biggest way that our statute is stronger than the federal one is that it requires a judge to release someone if they find that the person qualifies for compassionate release, which are generally the same criteria beyond the 60 versus 70 thing that I mentioned earlier, and they find that that person isn't a danger. And so because judges have to release someone if those two conditions are met, if they fail to release someone, we go to the Court of Appeals. We just actually had a reversal yesterday. So we can create case law that also guides other judges. So when vaccinations were becoming a big basis to deny cases, the Court of Appeals in a decision called Autry actually happened to come out right in the middle of the Omicron surge. And they said, that's going to only be part of the equation. That can't be the entire equation. We have to look at people individually. So we are very lucky. And I couldn't agree more that there's such a range in terms of how quickly judges act. And one thing I'll just say is our courts, we've had some cases that have been pending for more than a year. On the other hand, we had a case that we'd lost. We found out that the client had subsequently received a terminal cancer diagnosis, and we were able to get him out within 2 weeks. After that, the government didn't oppose. We filed a motion, we had a hearing, and he was out, and it was incredible. He went into a hospice, so it's all, very sad, but it's certainly, there is the ability to act urgently at times.
Thanks, Vida. This makes me want to ask Alison a question, which is, I know you actually had an opportunity to testify in Congress and about these issues. And so, what is the chance is there a chance, and what do you think the appetite might be for any change in the federal law, in the federal system, any of these? I mean, the idea that Vida just raised of you essentially limit discretion in the direction of mercy. I mean, that is it seems like a very powerful mechanism for increasing compassionate release. So what is your thought on that?
Oh, I mean, I am not a politician, and I have become so disenchanted with the whole conversation about criminal legal reform in Congress. I mean, including listening to yesterday's confirmation hearing for Nina Morrison, and just this idea and approach that we have to mercy and innocence even. So I get the sense that there are concerns, and I think this was clear from the congressional hearing, there are concerns from both sides of the aisle about conditions of confinement. I think the question is going to become what happens as a result of those concerns, and one side of the aisle really fearing this increase in crime and increase in violent crime that somehow is going to infiltrate the entire nation. And the other side, I think, also fearing not coming across as soft on crime. So honestly, I would suspect nothing happens, although I know there are people who are much more savvy politicians than I who are going to be on panels tomorrow. Mary Price from FAM, for example, probably has a much better perspective on this. But I think that really where any change is going to occur right now, if it does, is at the individual court level. And I'm not particularly confident at that, but I think that, really appealing to our district court judges and really highlighting the human toll and not treating these compassionate release cases as sort of a rote motion, a copy and paste job. And that's really hard. That's really hard because federal defenders' offices are handling, I don't know how many of them. And if they don't handle them, then the person goes pro se. And so we just don't have the infrastructure needed to really build up a robust sort of well of knowledge from which a lot of these judges can draw. And I have been really focusing a lot on some of the civil litigators who have been doing phenomenal work in challenging conditions of confinement in Danbury, in Terminal Island, in Lompoc. And the work that they do, I don't think we incorporate enough in the criminal realm. And so I would just encourage people to sort of look at these big civil cases and then try to use those to push for compassionate release as well.
Thank you. We got a great question from the audience that I want to now just put to all the panelists, and anyone who wants to can jump in on this, which is, can somebody talk about medical compassionate release for mental illness specifically?
Well, I've raised it a couple of times and it hasn't worked. So I mean, I think at least in the districts where I practice, the assumption, it's very much the assumption, I think across the United States, that something that's a physical ailment that's much more tangible and easier to see is going to be the basis for compassionate release, even though in fact, the purpose of the statute talks about mental illness and in fact provides provisions for it. I haven't seen a lot of appetite for that, but I don't know if any of my fellow panelists have.
We had one case for someone who was both cognitively impaired and suffered from mental health issues. And he didn't have much time left on his sentence. And it was before vaccinations were widespread where we were successful. But apart from that, that's unfortunately not an area that we've seen a lot of victory. And I think advocates for good reason are afraid to talk about it in their pleadings, because for fear that judges who have an incomplete understanding of mental health and mental illness will try to substitute mental illness for dangerousness. And so it is something that I think you have to be strategic about, unfortunately.
We are preparing to file a few motions on behalf of people with mental illness, mostly dementia. So check back in with us in a month or two and see how it's going. But these are people who are very elderly and who, now do need assistance with many activities because they are so impaired. And it raises a lot of other questions or difficulties around reentry because these folks need nursing level care. Probably they need memory care. So, compassionate release is hard, and compassionate release for folks with mental illness is probably even harder.
And just to echo what Vida just said, I think that there's a lot of stigma for people with mental illness, and it often becomes proxy for dangerousness for judges, or at least something that makes them wary right? Because they're worried about that newspaper article if things go wrong, and they don't feel expert in assessing that. And so I think it's really important in those cases to have mental health experts. And I think one of the things that we as attorneys and advocates need to do is better educate judges, parole boards about mental health issues. And particularly, I think judges have a hard time understanding the relationship of incarceration and mental illness. And I think they feel like people are safer locked up, but that also has these tremendously detrimental effects on mental health. And so you could have someone who out of the custody setting would be much higher functioning and look really different because of social supports. And, like a lot of our clients with mental illness are really scared, and rightfully so, because we know they're subject to higher rates of abuse and violence because of that status. Like there's research that when people see people getting pills on the line, then they target them for violence because they know they won't be likely to be believed. And that's something we don't talk enough about.
I was just going to say, one of the other things that I think has really exacerbated mental health problems during the pandemic is that when we're talking about medical isolation in prisons, we're really just talking about solitary confinement. And so, we see an increase, at least with my clients, in the clients that I've represented, in the appearance of mental health symptoms that were otherwise not as apparent. And again, with the no programming happening in the Bureau of Prisons, I don't think people are getting treatment. But I do really worry, at least in the districts where I practice, that you raise just a mental health claim for compassionate release and it just devolves immediately to dangerousness, just like Vida said.
Yes, I'm personally dealing with the dangerousness problem in the bail space too. And it's just, it's everywhere, the sort of the Willie Horton fears. That the judge is so afraid that they're going to be the person who releases the person who goes out and does the terrible thing. And even no matter how much data you talk about, no matter how much you say that incredibly rare, there's just that sort of that fear of being personally tied to the person who, who does the bad thing. It's really hard. It's really challenging, I think, for all of us as practitioners to understand how you surmount that. In both, bail and compassionate release spaces. One other, I'm going to put a question from the chat, from the Q&A, the audience. This is focused specifically on the federal system and the requirement that you provide, extraordinary and compelling reasons when you're seeking compassionate release. And so the question is, how are you battling the perception that regardless of the case numbers, COVID-19 is on its way to becoming endemic, and therefore COVID is simply no longer anything extraordinary or compelling?
At least for me, sort of the framing of the issue is one that doesn't just focus on the likelihood of infection, but rather focuses on what does a prison system in a persistent state of potential infection mean in terms of conditions of confinement as compared to a prison system prior to COVID. And so for people who were sentenced before COVID, the extraordinary and compelling reason, at least in my mind, is there is still a risk that they would get infected. But even if there's no longer a risk that they're going to get infected and died, what we visualized or conceptualized as the time that they were going to serve in prison when they were sentenced has materially changed. Right. And it is no longer that somebody goes and they do their time and they do their RDAP and then they get released, which is what judges tend to think. I think, know that the reality is a little bit more complex than that. But that now it's you go and you sit in your cell 23 hours a day. You're not doing any programming. You don't even want to get tested for COVID, because if you get tested for COVID and you test positive for COVID, they throw you into solitary confinement. And then you got to spend the time in solitary confinement. And if there's an outbreak while you're in solitary confinement, then you don't get out of solitary confinement. You've got to stay there and even longer because they're not going to put you back in a pod with people where there's an outbreak. So it really does change sort of our understanding of what prison is. And if we think about our people's time in prison as attempting to develop some sort of normalcy that when they return to society, they're going to be able to quote unquote reintegrate, we are certainly not accomplishing that under COVID conditions. And so I think just shifting the narrative a little bit to say it's not just a matter of infection, but the whole prison structure has changed dramatically since COVID in a way that doesn't further what you judge see as the purposes of punishment.
I'll just add, because our statute also requires that we show extraordinary and compelling grounds for release. And one thing that we've really focused on is looking at debilitating medical conditions. So beyond just that COVID angle, just talking about how debilitating it is to have something like diabetes or chronic kidney disease or hepatitis, heart disease, these things that, you know, really just sound common, but are extremely lethal. Spending time looking at that rather than focusing as much on COVID as we have.
Thanks, Vida. I'm going to just ask, can one of you sort of reflect on, to end, you know, to try to move us towards a more positive place where we might end this panel. What gives you hope when it comes to medical compassionate release? What makes you hopeful today?
I'm going to just hop in because I also have to go to teach my class in a second.
Yes.
But I think that by focusing on these medical conditions that so many of our clients have, that judges will hopefully come to the understanding that we're not just sentencing people's brains to prison. We are sentencing their bodies to very negative consequences. The diet, the environment, the stress, the trauma all contribute to a much shorter lifespan just from entering those prison doors. And that's something that I think this litigation is shining a light on.
Yeah, I think from a public defender perspective, not having worked in a district with a prison, so not doing a lot of prison-based litigation, litigating in this space has really helped me understand truly the conditions that my clients live in a way that I didn't understand before, which I think has made me a much better and more empathetic advocate. And so I think there's not a point in my career, if I think about going forward, that I will ignore or feel like I even can ignore what's going to happen after I leave my client, right after that sentence is imposed. I think now as public defenders, we have to be thinking about everything in the future. And I think that's a really good development.
Thank you, Alison. Now, listen, I don't want anyone to go anywhere. I see I have 187 participants here right now. I am asking right now for no one to leave this Zoom room because this panel is not over. There's a really, really important piece right now that we're about to address, okay? So I'm watching the numbers. Thank you. I feel like I'm on an infomercial, but don't leave. Okay. I'm going to briefly just say thank you to these incredible panelists before I get to the coda of this session. So I want to really thank Vida, who has to go and teach. I want to thank Alison and Amy and Mira, all of you so much for your unbelievable contributions, both in this area and in this panel. It's really mind-blowing, and I feel so honored that we were able to hear from you today. But before we end this panel, I have a very special announcement, which is that this month marks the 10-year anniversary of Professor Erica Zunkel joining the Federal Criminal Justice Clinic. So Erica, I know this is an enormous surprise, but I would ask you to please turn on your camera. Thank you. I'm gonna share screen for a second here. This is a small token of our appreciation, Erica. You're gonna be getting a framed version of this artwork for your office wall. It includes the name of every single client you've represented in the clinic, along with every student you've ever worked with, and also organizations and projects that you've devoted yourself to and just poured yourself into. And I just want to take a couple of minutes now to talk about Erica's really exceptional contributions to the Federal Criminal Justice Clinic over the past 10 years. Erica, as a lawyer, you are a defender's defender. You are just the ultimate zealous advocate. You bring to this work the utmost compassion, for your clients. You also bring this brilliant ability to take this case law that's always so hostile to the defense and just like jujitsu it into a winning argument. And then you have many other superpowers, one of which is you're an unrelenting investigator. So, you leave no stone unturned when it comes to fact gathering. You hunt down witnesses, you secure written records, you conduct interviews, like you do everything you can possibly do to figure out everything you can know about a case and a client. And on that note, you also invest so much time into developing a truly deep understanding of each and every one of your clients and their circumstances. And, you forge these wonderful, beautiful, lasting relationships with your clients and with their families. With all of these skills, it's no wonder that you're a formidable adversary. It's no wonder that you're a fierce negotiator, and no wonder that you win just unreal victories for your clients, our clients, and that you lead the students along with you to those victories. And so as a teacher, Erica, as a clinical supervisor, you devote yourself entirely to your students the same way you do to your clients. You're always developing innovative ways to improve our teaching and our supervision. You're beloved by every student fortunate enough to work with you. You're also just like on a very personal level, an extremely supportive colleague. You provide me and Judith with just incredible insights on the thorniest questions. You help us through really difficult times. And I know we've all been through hard times together, and you've supported us throughout, and I think it's made all of us so much stronger. And somehow, I don't understand how you managed to do all of this while raising 3 children, ages 5 and under. So your vision for this Second Chances Symposium really, I think, exemplifies your stellar gifts as a lawyer, as a teacher, as a change maker. So it seemed like the perfect time to celebrate this milestone. Erica, over the past 10 years, you've had a transformative impact on this clinic. So on behalf of the faculty, the staff, students, and alumni of the Federal Criminal Justice Clinic, I just want to thank you for your extraordinary teaching, advocacy, and friendship. I think it's going to be really hard to top this first decade, but I cannot wait to see what you do next. So everyone, please join me in just huge round of applause for Erica.
I'm truly speechless at the moment. And just truly blown away by that. Thank you, Alison, so much. I really do not want to cry before the panel that I'm going to moderate in 15 minutes. So I will try to keep it together. But thinking back, just this might be kind of scattered right at this moment. But when I came to Chicago in February of 2012, I had no idea what my life would be in 10 years and how much you, Alison, would change my life, giving me this opportunity, teaching me, mentoring me, showing me so much about how to fight for clients, fight for bigger change, your vision. You are a visionary, and I've learned so much from you. And what I think about is how lucky I am to work with our students, who are just like the most incredible people. And I know some of our students are on here, and they inspire me every single day with their creativity. To Alison and Vita's point, they are, shaking me out of my feelings of this is what the status quo is. And the work that I'm doing now is built on the work that I did at Federal Defenders in San Diego. And I just want to shout out my colleagues from that office, because that's where I learned to be a lawyer. And if you want to learn to be a fierce and fearless lawyer, go to San Diego. You can be with lawyers like Amy Kimpel. I know there were people on the chat from San Diego. Judith Miller, my colleague, we worked together. It's so many other people. But the reason that I did this work is because of the people that I'm representing. And that's been the biggest and most wonderful blessing in my life, getting to fight for people. So that continues. There's a lot of work to do. Thank you, Alison, so very much.
Thank you, Erica, too. I know I surprised you, so it's it just shows what a great lawyer you are, that you just like had an incredible acceptance speech without knowing anything was happening. Everyone, I just want to thank you all. Again, I want to thank our panelists for this medical compassionate release panel. We've got another amazing panel coming up right after this in about 15 minutes. So please do stick around, and we will see you. We will keep seeing you.
Thank you, Alison, for moderating that panel. It was fantastic. Thank you to all of our panelists. I absolutely love that it was an all-female panel. There aren't enough of those. So we'll see you all in about 15 minutes.